Okay, shall we go ahead and make a start? We're happy to do that. Yes. Okay, excellent. So welcome everybody. This is fantastic to see so many of you here. We are expecting quite a few more to be coming in, so that people will be entering, I think, over the next few minutes. So welcome to the second of our online discussion events for INCCIP, or the International Coalition for Children with Incarcerated Parents. Bit of a mouthful. Really pleased to welcome Benoit. I'll do a proper introduction in a moment, but just a bit of housekeeping first. Please feel free to keep your cameras on so we can actually see who's here and make it a bit more of a collegiate conversation. But equally, don't feel that you have to turn your camera on. It's totally up to you. Please do remain muted while Benoit is speaking, but then we'll open it up to discussion after that, because I do want to have a conversation about all this. It's a really important topic. We've obviously got the United Nations Committee on the Rights of the Child preparing a general comment regarding children's access to justice and effective remedies. So as a network that focuses on children with incarcerated parents, obviously there's some huge relevance to us. So INCCIP will be preparing a response to the general comment, or I'm not sure if it counts as a call for evidence to inform the general comment, or whether we comment on the comment after, or both. But hopefully you'll tell us about all that, Benoit, in terms of process. So INCCIP will be submitting something, and the Child Rights Connect working group on children with incarcerated parents will also be submitting something. And this will be recorded as an event. So for those who wish to prepare their own responses on behalf of your own organizations, then hopefully this will be able to perform that. But it's a real opportunity to discuss the implications of the general comment for the children that we support, and to inform your own responses. So I will stop talking. I'm going to hand over to Benoit, or introduce Benoit Van Keirsbilck, because Benoit is a member of the UN Committee on the Rights of the Child. I know you've had a kind of a long-standing interest in this particular issue, Benoit, because I know we've met at a couple of events in relation to children with incarcerated parents. So I'm very pleased that you're willing to speak to us and have taken the time to let us know a bit more about the general comment and how we can feed into that. So I'll hand over to you just now, and we'll come back when you're finished. So thank you so much.
Thank you so much, Nancy. I hope that everyone is hearing me well. If not, please let me know so that I can adjust what is possible to adjust. So it's a real pleasure to meet you. I know some of you, and have been interacting indeed with some of you for a long time. And especially I think that during the time of the global study on children deprived of liberty, and you were advocating with great success on the need for this global study to cover children with incarcerated parents, although not all of them are incarcerated with their parents, but we know that the deprivation of liberty of the parents have an impact on the whole family. And so that was also a great work where I had also to think more in depth about the situation of children whose parents are deprived of liberty. And it was a great and learning experience. So I think that this work now that we are starting may also be a great experience, and that we will be able to produce something that will be helpful for most of you. So just as Nancy said, I'm a member of the Committee on the Rights of the Child. It's my first mandate, the third year of the mandate. So I don't have such a huge experience, but still I knew the committee from before, and now sitting in the committee, I tend to understand how it works and how we can manage and make our points and use it in a strategic way. So that's already something. And I'm running for a second mandate, and I hope I will get it mainly because I started this very fascinating work, which is to lead the drafting of a new general comment. So I don't know how much, I guess that you are all familiar with the role, mission, and work of the Committee on the Rights of the Child. If not, don't hesitate to ask me more questions later on. But I start from the point of view of a certain level of knowledge of most of you. I hope it's the case. But just to clarify what is a general comment, you know that the main mission of the committee is to review states. States are producing their regular reports and we review it. We have a dialogue with the civil society, UN agencies, very often with group of children, to inform us about the situation of children's rights in one given country. And then we issue concluding observation concerning each country that is coming to us. And we do cover in these concluding observation, you probably know that we do cover children whose parents are deprived of liberty. And it's very often something that I am able to raise during the dialogue, and to see that very much remains to be done in that field. And there is no doubt about that. Besides this monitoring process of the reports, we have other tasks and duties. I just recall that we have this fabulous mechanism, which is the OPIC, the Optional Protocol on Individual Complaint. It's only useful for states that have ratified that protocol. That means 52 states for the moment, mainly in Europe, Latin America, and then some in Africa and Asia. But this gives the possibility for children to come to us and to, after having exhausted domestic remedies, and to bring a complaint because they feel that the rights haven't been fully respected at national level. I also mentioned that because it's something to keep in mind. I'm sure that all of us, we can imagine many kind of situations that we could bring to the committee through an individual complaint. And so supporting children, supporting lawyers in this mechanism and bringing case also through a strategic litigation procedure, it may also help to advance some of these issues and try to set up some standards on the matter. We have had a few cases that we had to deal with when either the child or the parents were deprived of liberty or at risk of deprivation of liberty. So we have already some decision there, but I think that we could do better. And if we receive some good cases, we could try to clarify the principle that should be applicable in that context. The OPIC also allows the committee to start an inquiry, which could be done when there are grave or systematic violation of children's rights in one given country. This doesn't need to exhaust domestic remedies, but it's more on a global issue and not individual situation. But here again, I just mentioned that to encourage you to bring some cases or some situation to us so that we can also look at it and try to identify what can be said about that. And then finally, we have, among many other tasks, and I will not enter into all the details, but we have the possibility to issue draft general comments. So most of you know we have already 26 general comments, and they cover a large, broad kind of issues on different topics. It can be some specific rights, and it can be some more global situation. And a general comment is really seen as a global interpretation, we say authoritative interpretation of the convention. So we start from the convention, what the convention says, and we try to give more flesh to the convention and to try to inform the states on what is expected from the state in the implementation of one specific topic. We give guidance on how to apply the rights, how to apply the main principle of the convention. What do we have a concrete example? We try to also reflect the views of the children in this context, and to give some global understanding of what is expected from the state in monitoring and implementing the convention. So having said that, we have decided, the committee has decided now to dedicate its next general comment on children's rights to access to justice and effective remedies. So first of all, we just to make it clear, we have already the General Comment 24, which deals with more children who are confronted to a justice system, but as offender, and to clarify what should be how to respect the rights of children who are suspected or convicted of an offense in the child justice system. But here we want to be much broader and to look at the situation, all the kind of situation where a child has a need to have a legal response, a decision, a remedy. The starting point is, and it's quite obvious for most of the ones who work in the field of children's rights, but it's when a child has a right, there should be a mechanism that will help the child to have this right being respected. So it's really about justiciability, about accountability of those rights. It's of course valid for adults and for everyone, that's no doubt about it. But when it comes to children, we all know that the obstacles, the difficulties that a child will be facing in trying to access to justice are many at different levels. Of course, the first obstacle that we can think of is the fact that a child in many legal contexts is seen as not being legally able to bring a case to a judiciary, to a court, a judge. He has usually to be represented by the parents. And of course, very often supported by a lawyer, by other legal actors. But the first difficulty is indeed to have a legal standing when it comes to requesting and asking for implementation of the rights. There are many other obstacles, and when it comes to children who are whose parents are deprived of liberty, we know that those parents, even though they have usually, not always, but usually they still have the legal representation of the child, are the legal guardians of the child. They are very often in a very difficult and weak position when it comes to defending the rights of their own children. And it may be also the case that sometimes the parents may be in prison because of a crime or an offense or something that have done against the child, and the child is victim. So that's a specific context. We have many other obstacles: poverty, lack of information, the distance sometimes, the fact that reaching out to a lawyer is not easy. The system are very intimidating. The procedures are very long, and usually the child is not taken seriously in all these contexts. So altogether, we know that there are a lot of difficulties, and we want to, through this general comment, to address most of those difficulties. We are talking about remedies and access to justice and effective remedies. So, of course, the justice system is ultimately the system that has to look at the implementation of children's rights and try to respond to a situation where a child is facing a violation of his or her rights. But before reaching out to a justice system, we know that the vast majority of children in the world will not have access to a formal justice system because it's not in place, because it's not accessible, but also because in many places the system in place is a customary justice system or a traditional justice system, and so on. And so we also have to look at and take into account all kind of system that is in place in all countries. Otherwise, we just ignore a vast majority of the children. But so this general comment will indeed also try to clarify, define what is access to justice, what is a remedy, what is expected from the state from the point of view of informing, educating, supporting children to implement their rights, what are the mechanisms in place, but also how to improve the existing mechanism and justice system to make them a bit more, sometimes we say child-friendly. We know that this wording is not always adequate because the judicial system are not usually friendly as such, but we child-centered, adapted to the situation and the needs of children. And this is exactly what we also need to ensure, that children are really effectively heard. One try to avoid everything that is intimidating, that will provoke a new violation of children's rights, harm the children, or be a new way of hurting the child in what he or she is facing. So we have to work on the situation of the child, but also the response from the state. So that's what we would like to do. The concept note is explaining and giving a first definition, and we can enter into that if you want, of what we consider being access to justice, what is a remedy. The remedy is a broad concept which encompasses compensation, restoration, apology, or it may be understood in very different ways. A system that will respond to a solution, to a situation, but also a compensation at the end of the decision, which is may also be important. So we will work on the definition. We will work and also on the scope and the children who are targeted. And coming to that, I think that we would like to keep in mind that if we want this general comment and the convention to be effective and not to forget some children behind, we have to look at the most vulnerable children. And the children who have more difficulties, they don't know the language, migrant children, children with disabilities, children living in poor areas, and so on. And I think that children whose parents are detained, deprived of liberty in several different contexts, are part of those children who may face more difficulties, and even more if they have one of these characteristics that I mentioned, being migrant and so on, belonging to a minority and so on. So we are looking here at the situation of those children, and what we have to think about is what kind of specific needs they would have in implementing their rights, keeping contact with the parents, being able to visit them, fighting against discrimination, the level of living, because when a parent is detained, very often there is a consequence on the poverty of the family, and so on. So we have a lot of issue to deal with. And what we need to think about is what kind of remedy, what should be in place that will bring solution for the children. So that's in the context of your work, your scope, more precise scope. We will have to look at that, and I would like to ensure that we don't forget those categories of children and that the general comment will also address their needs. So globally, the objective is really what we call provide authoritative guidance to state party to undertake all appropriate legislative, administrative, and other action to ensure children's rights to access to justice and effective remedies. And so that means also to set up in place or support services, lawyers, paralegals, and so on that are trained and that are able to deal with children and take into account all the context of the situation of those children. What will be the methodology? So the methodology, we have a concept note, it has been published, and the next step will be that we will launch a call for contribution. So it will be a general call for contribution based on the concept note, and we will ask everyone who is interested to send us a contribution, a written contribution, not too long, because we will be overwhelmed with many documents, so we will have to digest them and to be able to face all of them. And so we will need to receive all those contributions and ensure that they cover all aspect and all dimension of the question. And so for you, it will be great to have, on the one hand, contribution explaining on how this general comment can deal with the issue of children with incarcerated parents, but also to highlight some interesting practice, some policies that are in place in some countries and that we can promote and things like that. So we need to have your contribution to make sure that we cover this issue. So there will be a launch for contribution. There will be also, and very important, child participation dimension. So we need and we have to take into account children's voice in this exercise, which includes the possibility to reach out to all and different categories of children, and to start from their experience. What is their experience? How did they live and went through judicial proceedings and other situation where they need to be heard and make their points and make their vision be taken into account by the justice system. So child participation will be crucial. We will develop a methodology for that. We will promote the organization of focus discussion, focus group discussion with children, of course, including a child protection policy to make sure that we do it properly. And we will ask that each organization that wants to develop such a focus group will provide us with a report and with quotes and the experience of children. Besides that, there will be many presentations like this one, and then many expert meeting, national and regional meetings, either, I mean, to focus on one specific region and also on the existing mechanism at the regional level. We also have to look at the mechanism in Africa, in Latin America, Europe, Asia. What are the mechanisms in place to ensure that children are that the rights are implemented? And we will also have national meetings and national consultation with professionals, with different stakeholders that will also provide us with their feedback. There will be a zero draft then drafted, and I hope by mid-August. The committee that will gather in September will have a first debate on the outline of this general comment, and then still some time in autumn for consultation and children's consultation, and then in probably March next year, there will be the draft 1, first review by the committee in May. And so between March and May, there will still be some space to comment specifically that draft, that version of the draft, and then final adoption either in May or September. I mean, this is a tentative of timeline. We will have to see how we can manage with that. So that's more or less the timeline, the different milestone, and how we want to work on it. And then once it is adopted, then of course we will need to promote it, to present, to use it as a tool, to ensure that states are engaging with this general comment. So that's a very long introduction already, so sorry for having been long. And now I really would like to open the floor and to listen to your comment, suggestion, what needs to be in place, how do you plan to contribute if possible. We are really open to this to make sure that we really look at all the aspect of the situation and try to cover most of it. You know that there is a limitation of number of words, and so that means that we cannot also we cannot be too long on all aspects, but we will try to cover most of it. So that's my long presentation. I'm open for your comments and all suggestions. Up to you.
Perfect. Thanks so much, Benoit. I really appreciate that. So I've put the link to the concept note for the general comment in the chat, for those of you who haven't seen it. Benoit, can I just clarify with the timelines? You said that you're doing a draft by mid-August. Did I catch that right? That in terms of what you're looking for from
Nancy, I don't know if it's only with me, but your the sound is not very good. It's cutting. Sorry, Nancy, I cannot hear you well. Okay. I don't know if it's only for me.
Is that any better?
It's better, yes.
Okay.
I didn't get what you said.
I got the warning saying my internet is unstable, so I'll try not to speak. Can I just clarify about the timelines? When are you looking for comment from other organizations? Is that before this August?
Yeah. So the launch for contribution will be out mid-May or at the latest end of May. So before the end of May, it will be out. Probably mid-May. We still have to fine-tune the call itself, but it will be there. And then I think that there will be something like 2 months to send contributions.
What I'll do is I'll put as I said at the beginning, INCCIP will be compiling a response, as will the Child Rights Connect working group. And I'll put the INCCIP email in the chat if people want to contribute something but don't necessarily want to write their own. It can feed into the contribution. But I am keen to let people ask questions and make comments and things. And Rachel's hand is already up, which is wonderful.
Actually, thanks, Benoit. Benoit, one of the issues that comes up repeatedly for children with imprisoned parents is that visiting a parent or maintaining contact with an imprisoned parent is considered by the prison authorities to be a privilege of the prisoner, not a right of a child to maintain contact. Now, we know as well as I do that under the CRC, they have a right. In fact, COPE did an amicus brief jointly for the European Court of Human Rights. Then the court actually took it up in relation to a pre-trial detention in this case, because you have the two situations, and the prisoner had not had contact with their child for a long time. Now, in those cases, it's very rare that the child is a party to the European court case. So there is an issue about the general access to justice. There's a question then about how how they can actually be represented in that situation. Now, in that case, the court was willing to accept an amicus brief, and we were obviously, with our partner, were focusing specifically on the child. There was another parent as well, but we didn't comment on that. And they did take account of that amicus brief and said indeed that the child had a right to have contact. We can obviously will include that in one of the submissions. But this is something that is actually so common across almost all jurisdictions. And you have the blanket, the person in pretrial detention, they can't access people because they might interfere with the justice system or whatever. And then you have the general visiting and removal of privileges, or not allowing this as a privilege, whereas we're saying this really is a right of the child, and how can the child assert that right? And I think this is one of the crucial things that this general comment could make such a big contribution to. Thanks.
Thank you. Maybe we can listen to different comments and questions, and then I can react, and we can engage in the dialogue. Yeah.
Ahmed, do you want to come
in? Thanks, Nancy. Thank you so much, for your introduction to this important general comments. My question was, when you started your introductory speech about the OPIC, the optional protocol individual complaint, and I was just a little bit confused that if the general call for contribution is limited to those who ratified that optional protocol, or as a general the country that's like mine that haven't ratified beside others, and activists like myself can contribute and give some feedbacks on that also as well. Thank you.
Mm-hmm. Okay. I see in the chat. What are your thoughts about the US not being signatory, and thoughts about why not? Any strategy to encourage them to adopt the CRC? Yeah, that's a traditional question in the field of the convention. So maybe just to answer to those few questions and to start with, concerning the US, it's really a pity that the United States haven't engaged in the convention, and it's even more strange because they have ratified the two optional protocols, the two substantive optional protocol on sale of children, child prostitution and child pornography on the one hand, and children and armed conflicts on the other hand. So that's very strange, and it has always puzzled me that one state can ratify the protocols without having ratified the convention itself. So there is a lot of debate, discussion, and the reason why the United States haven't ratified that. We know that the fact that the death penalty is still in the legislation of some states, lifelong imprisonment for children and without parole. We have also the family right agenda that is sometimes very strong in some countries, and they see the convention as being giving agency to children, but against the right of the rest of the family and the parents. So there is an interpretation and reading of the convention that is not really in line with what it is. And there are probably many other reasons, and one of them is probably also because they don't want to really go through an oversight mechanism and comply with this possibility that the committee has to check how much they are implementing the convention. But it's a long debate. I have many friends in the United States that are really working very hard for many years to try to have their country ratifying the convention. At one point, they managed to have it in the program of one candidate and who became president, because Obama had the ratification of the convention on this list to achieve, but he didn't. And so, yes, it's still there in the air, and maybe one day they will ratify. But that's a broader question, of course. Concerning, to take it the last one before, I'm sorry if I misleaded you. When I presented the OPIC, yes, indeed, only children coming from a state that ratified the OPIC can bring a complaint to us. That's children living or complaining about the implementation of their rights from a state party. Just to give you an example, we have children who are in the camps in Syria, and Syria didn't ratify the OPIC, but who their case was brought to us by the grandparents that live in France and in Finland, and they asked us to decide on the rights of those children, and we said that both France and Syria have the obligation to do whatever they can to repatriate them. And so we had to intervene for a child who is not in a state party, but still it's against a state party. The action has to be taken against the state party. But that doesn't mean that only those children or those actors that are working in a state that has ratified, it's not only them that can contribute. Anyone, even, I mean, from the United States, we will receive comments without problem. So we will take into account all contributions. And this can include indeed the idea of ratification. How can the General Comment advocate for the ratification of the OPIC, because the OPIC is indeed an international mechanism that will add a possibility for a child, if he is not heard properly at national level, to bring the case at international level. So it should be implemented and accessible in all states. And so little by little, we have to continue convincing states to ratify this OPIC. It's part of the whole system. So please don't hesitate to send your contribution. It will be very much appreciated. Then when Rachel's comments, I cannot do anything else than agreeing. Of course, yes, I do agree on the difficulty for a child to appear even in a dispute, to be taken into account. And this is something that we also see through the OPIC cases. Sometimes it's, of course, brought by the parents, but it appears that it's the parents who are defending their own rights. We are there to look at the situation through the eyes and the situation of the children themselves. And I'm very happy, and please inform me if I missed the decision. When the decision of the European Court on Human Rights will be out, it will be absolutely important. And this example is really important and interesting, but that means also that we have to educate lawyers, that we have to educate many actors at national level, because when we have to act at international level, you know that there is this rule of exhaustion of domestic remedy. But if a child hasn't started a legal action by him or herself, on at least under his or her name at national level, we may have to say, sorry, you didn't exhaust your domestic remedy. You should have gone to the national court, and maybe the national court could have given you an adequate response. Of course, the committee, but also every regional human rights jurisdiction cannot deal with all the needs for a judicial response. So we would like, and this is also an objective of the OPIC, we need to have a better, stronger, and more robust judicial system in place at national level that take into account the children's rights and that will look at the situation through children's lenses. And so, yeah, absolutely, having an agency in legal action is crucial. Just for the anecdote, but I had one case some years ago where a mother was detained in France and suspected of drug trafficking, and she was living illegally in Belgium before arrested, and the child was alone in Belgium. And so the mother detained in France, the child in Belgium, put in care, and it was just impossible to find a lawyer willing to bring the case to a court and to give a possibility for the child to be to visit the mother, and it lasted for months and years. But just having a lawyer willing to bring the case on behalf of the child, I had to go to the head of the Bar Association and the head of all the Bar Association of France to claim the right of this child to have a lawyer. And it took months before they accepted to appoint a lawyer for this child and to bring the case on the name of the child. So I know how difficult it is to bring those cases, to give an agency and to allow a child to intervene in one procedure. And so that's absolutely crucial. And but this is also a difference that we have between a procedure at national level or at international level. At national level, very often you need to have some legal representation for the child, which is not the case at the level of the European Court on Human Rights or the Committee on the Rights of the Child. So a child, no matter what is his age or her age, how old he is able to make to have the capacity to express himself or herself. We will receive the case from the child, even if there is no legal representation and he's acting by himself. So this is absolutely crucial, and we will have to see how to state it in the general comment, and because of course at national level we have to ensure that the legal provision at national level are respected. So states will be asked to put in place a system that will guarantee that every child has a legal and autonomous access to justice. But yeah, those examples will really highlight and clarify what is expected from the state. So we will need those kind of examples.
Are there other questions, or indeed other examples of the types of things that we might feed into the general comment? We've obviously had the really crucial one that Rachel raised at the outset in terms of contact with a parent in prison, for example. Are there other examples that people would like to raise, or indeed examples of positive practice? Ben has a question in the chat about the power of the UNCRC to change things for the better for children who request a remedy. So how much power does the committee have, I suppose, to change things for the better? But are there other questions, comments as well? Sorry, go ahead, Benoit.
No, if there are other questions, maybe first. No, it seems that is not the case. So the power in practice of the UNCRC, that's a very big one too. But no, in fact, I think that I really believe that combining many ways of advocating and trying to bring some change is effective. And in this regard, the convention is a legally binding instrument. It has to influence legislation. It has to influence practice policies. It pushes states to adopt a plan of action. It pushes states also to invest more in children. Of course, not enough, not at the level that we would expect, but still we have many examples that things are improving to some extent in some parts of the world. And we have also example of backslash and the fact that in some countries the situation is deteriorating very fast. The more obvious example, it's children in the context of war and armed conflict, but we also have Afghanistan, where children lost their, and especially girls, lost most of their rights from one day to another overnight. And so, but I think that combining, you know, the reporting process, the fact that very regularly the states have to come to the committee and try to justify, explain, and demonstrate that they are willing to invest in children's rights, combining that with the other mechanism, and also and very much with the work that is done at regional and national level. So our concluding observation are, of course, only a written document that can be easily forgotten by the government if they just want to put it under the shelf and forget it until the next review. But when we have actors who are using it, and in many countries we see that it can change things, it can be used in court, it can be used in the parliament, saying, okay, the committee asked for this, now you have to comply with this principle. So we have fortunately a lot of examples, and I think that Scotland is also a great example in this regard, because now the convention has been embedded in the constitution, if I'm not wrong, and that's a great example, because then you have that in the fundamental principle of the state, you have the need to take into account children's rights, and then it has to be done at all levels in legislation, practice, and so on, and you have a mean at national level to use it. So yes, I think, and through the OPIC, we have also many examples where it has changed the life of many children, and not only the children who brought the case to us, but also more broadly. I very often use this example of one girl from Morocco living irregularly in Melilla, which is a part of Spain in the north of Morocco. And because she was undocumented, she couldn't prove legally that she was living there, and she was not enrolled in school. So she tried many times during months and months to be registered in the school, and the school was saying, no, we don't have the proof that you live in the country, in the state. And so they were refusing her request. And so she brought the case to us, and then we had 2 or 3 cases in a row, and each time we said to Spain, okay, now the right to education shouldn't be under the condition of living regularly in the state, so it's an autonomous right and so on, and you should put in place some remedies in case it's not applied. And then after a few cases, Spain decided to register all undocumented children living in the territory, and for Melilla that means 800 children had to be registered at once. So I mean, those examples, and we can of course multiply them, are very interesting, and this is also applicable for another state, because what we have said to Spain, we could have said it to many other countries. And recall that a child who doesn't have documents, legal documents for the stay in the country, should be also should have access to education. Fortunately, we have examples like that. but still, of course, it remains scattered, and we still need to continue. And it's sometimes a very long process, because we know that changing this legislation, changing the practice, changing the mindset and the mentality is something which is sometimes much more difficult than changing just one article in the law.
Thank you so much, Benoit. We only have a few minutes left, so I just want to make sure if people have, if you want to raise anything that you think we should include in responses to the committee, and from your own experience, from your own practice, I'm just thinking about the types of issues that can be particularly relevant for children when a parent goes to prison, such as the right to non-discrimination, the right to children having the being a primary consideration in decisions that affect them, right to privacy, right to their own identity, those types of things, right to having a voice. Do you have any examples that you'd particularly like to raise, or indeed, Benoit, if you have any examples of the types of things that you would expect to see, I suppose, from your own experience, that would be helpful as well.
I think that you mentioned many of them, Nancy. There are many issues. I know that, but I don't know how much this general comment will be able to address all the substantive issue, because it's less the substantive issue. You mentioned the non-discrimination, right to identity, and so on, but all of them that are linked to access to justice and remedies. And for instance, mentioning the right to identity is absolutely crucial. And on both ends, you need very often to prove what is your identity to have access to justice or a remedy. And on the contrary, you need the justice system sometimes to just recognize that you're not stateless, that you have a name, a nationality, and so on. So there will be one expert meeting in Geneva on the 18th of May, so very soon, organized by INCCIP and Child Right Connect and UNICEF on this specific issue, the right to identity, and linked to the access to justice. And that reminds me the fact that if your network or any actor is organizing one conference or one consultation specifically on the issue of children with incarcerated parents, if you see the possibility to add some workshop or some consultation on access to justice in regard to that, that is also a possibility. There will be many such activity and workshop organized in many places. We don't have to organize one specific workshop or a conference, international conference on that topic. We have to make the best use of all means that are existing. So don't hesitate if you are organizing something. We can also see if someone, a member of the committee of from the region, or someone can intervene in any workshop, and we want to learn as much as possible from all your experience.
But you'll see that Hamed has added to the chat about the question about data collection and just having information about who these children are, I suppose, or how many that we have. That's something that's relevant. I'm just looking at your question in the chat as well. Yeah, it's just, I don't know, Jess, if you want to elaborate on that, but is the question about how you know whether someone has children and the lack of communication, I suppose, between the different agencies involved. I don't know, Jess, do you want to comment, or Benoit, do you have thoughts about where you found that in your own experience? No, okay.
No.
Just
no, it's obviously relevant, important, and so, but it's maybe again more a substantive right, checking if the children are taken into account in criminal proceedings, and when a person is deprived of liberty and so on. But we will really look at what if there is a right that is violated because this child is not known by the system, and the system doesn't take into account the fact that this child must have access to his father or mother. We will look at what is in place to guarantee that this child can raise the issue to a court or another kind of remedy, because we don't need always to go to a formal court or tribunal. We can also think of ombudsman for children and other NGO mechanism, paralegal in some instances, and so on. We also have to be imaginative to make sure that a remedy is in place and really accessible for children.
Okay, we're in the last 3 minutes. Is your last chance to comment or ask questions, at least in the context of this conversation. Anybody else? Nope. Okay. I really appreciate your time, Benoit. This has been hugely helpful just in terms of knowing what happens next. We'll obviously be carrying on these conversations over the next few months. So you said that the call for contributions will be mid-May and due by, you said after a couple of months, so due some sort of in the middle of the summer, mid-July, and we'll make sure that you get plenty of responses from both from INCCIP and from Child Rights Connect, amongst the other individual organizations that are likely to contribute as well. As a reminder, I have I've put the link to the concept note in the chat, as well as the email address for INCCIP if you want to contribute in that way. If you're not planning to write your own response, we're happy to include response and thoughts in within the INCCIP response or within the Child Rights Connect working group response. So please do feel free to do that. I know, but just looking at the people on the call, we have all sorts of interesting people represented in terms of the Global Prison Nursery Network, in terms of Children of Prisoners Europe, in terms of the Prisoners' Families Group from the United States. So I think we should get an interesting range of contributions, including people from the US who feel very frustrated that we haven't, that the US hasn't ratified the UN Convention as yet. We're still working on it. We'll not give up hope just yet. But I think that's everything. We do have our next online event, hopefully will be a report from the study week in Uganda. That's the plan. The study week takes place at Wells of Hope in July in Uganda, and we're hoping that one of our board members at INCCIP will be able to report back from that event. So that last chance for any comments or questions, or not seeing any hands or people being brave to shout out. Very quiet group today. Middle of the night for some of you, I appreciate.
Thank you so much for the invitation, and looking forward to receiving your contribution, and open for next discussion exchange. If don't hesitate to reach out to us, and follow the page, the page on the CRC website for the news and call for contribution and so on. Right. And don't forget to also engage in child participation in all your context, because that's also very appreciated. Thank you so much.
Thank you so much to you all. Thanks for coming, and thank you so much, Benoit. Appreciate it.
Thank you.
Bye bye. Thank you.
Thank you.
Bye bye, everybody.